Welcome to this episode of the DMH Stallard Private Wealth Podcast. I'm Jenny Ray, a partner specialising in contentious probate. In this episode, I'm joined by Emma Weir, a partner and head of the private client team in Essex, and we're discussing LPAs. No one wants to think about a future when they might lack capacity to make decisions about their property, finances, or health and welfare. But as we're all increasingly living longer, there's lots of reasons why people may, at some stage in their lives, need additional support or be unable to make certain decisions. So, Emma, what is an LPA?
Hi, Jenny, and thanks for having me to discuss this important topic. A power of attorney is an important document which allows a person to appoint another person or persons to make decisions on their behalf, and particularly if they lose mental capacity in the future. The main powers of attorney that we're going to focus on in this podcast are called lasting powers of attorney, or LPAs. And there are two different types, one which deals with a person's property and finances, and another which deals with health, medical, and care decisions.
And LPAs are different, aren't they, to EPAs and general powers of attorney?
That's right, yeah. So I'll just briefly mention that there are a couple of other powers of attorney, which listeners may have heard of, and specifically an enduring power of attorney. An enduring power of attorney has effectively been superseded by the lasting power of attorney, but they were the main power of attorney that people would set up prior to the 30th of September of 2007. And that's when they were replaced by the LPAs. So if there's anybody listening that has set one of these EPAs up and they have been validly executed prior to that date, it would actually still be a valid document, and it could still be used now. A word of caution I'd add would be that an EPA only deals with an individual's property and financial affairs, so it doesn't have any effects on making decisions for health and welfare. So generally, the advice would be that if somebody has done one of these EPAs, they may want to review it and seek some further advice as to whether it needs updating or whether they need to do a health power of attorney to sit alongside an enduring power of attorney. There is also another type of power of attorney, which is called a general power of attorney, or sometimes you might hear it referred to as an ordinary power of attorney. And these are mostly used by people for making specific decisions. So you might see one if a person is living abroad and they've got a property in the UK that they want to sell, for instance, and they would like an attorney here to sign on their behalf and deal with the paperwork. They are quite limited though, so you can't have a general power of attorney if you have lost capacity, so they don't carry on for people that have lost capacity. So we only use them in very limited circumstances.
And we're talking a lot about capacity. Is it worth just briefly discussing what we mean by that? Because I think I often come across people who think there's a one size fits all assessment of capacity, whereas in reality the Mental Health Act asks us to look at each decision making, and of course you will have some people who lose capacity and it's not regained, but it can also be fluctuating. Is that
absolutely right? And the Mental Capacity Act that was set up in 2005 is very much around that area, in that people that may be suffering from something such as dementia or Alzheimer's, there is never really one point where they simply have capacity one day and they don't have capacity the next day. Oftentimes, people, even with capacity issues, will be able to make some decisions themselves, and they may need assistance to make more complex decisions. But the whole idea of the Act is really to empower individuals to be able to make as many of their own decisions as they can do. And even people who have set up a power of attorney, one of the specific principles of powers of attorneys and of the way in which attorneys act is really to state that the attorney should help the individual to make as many of their own decisions as they can, even if those decisions may be deemed to be unwise or foolish. And I mean, to be honest, we all make some poor decisions from time to time,
Absolutely.
and we don't necessarily lack capacity for that. So,
No.
it's capacity is a fluctuating
Yeah.
element.
Okay. And before we come on to look in detail at health and welfare and property and finance LPAs, did you want to talk a little bit about how someone goes about setting up an LPA?
Yeah, absolutely. So, the process for an LPA at the moment, it's relatively lengthy, only due to the fact of the Office of the Public Guardian has to register all powers of attorney. And currently, they are estimating waiting periods of between 16 and 20 weeks to set up a power of attorney. But the process is that an individual who wishes to set up a power of attorney will firstly need to decide who should be an attorney. And you can have more than one attorney. Um, Generally, most people have family members, often children, spouses, to act as their attorneys, but you certainly can have professionals as an attorney. And in some instances, it may be recommended, particularly if there are difficulties within your family. If, for instance, you have children who really don't get on with each other, and would be unable to act and make decisions together for you, that can make the management of the power of attorney very difficult. Uh, but the general process is that you decide who you'd like to be your attorneys. A document is created called lasting power of attorney, and there are separate documents for finances and for health. You have to sign the power of attorney. Your attorneys also sign. But at the time that you sign, you also need to have a certificate provider. And this is a person who certifies at the time that you're signing the document that you understand what you are signing, that you understand the power and the scope of the authority that you are giving to your attorneys, that you're not being pressured to make the power of attorney, and that you do have sufficient capacity. And that's the key thing. A power of attorney has to be set up whilst you have capacity to do so. And then once everybody has signed the document, it is then sent away to be registered at the Office of the Public Guardian, which is a government body that deals with powers of attorney. It's, as I say, it currently takes about 16 to 20 weeks, and a power of attorney is not valid until it has been registered.
Yeah.
They are currently actually, well, it should be happening in spring this year, piloting a new digital process for powers of attorney. So we don't have huge amounts of detail on that yet, but it'll be interesting to see how the process changes, and particularly whether there might be any change to the time period
Yeah.
for getting them set up and registered in the future. So I guess watch this space on that.
Yeah, absolutely. So with health and welfare LPAs then, firstly, what can somebody do? What powers do they have under that?
So a health and welfare power of attorney, it gives authority to attorneys to make decisions about somebody's health or care. It has the ability to make decisions about medical treatment, and the ability to make decisions about the care that somebody has, whether that care takes place in their home or whether they should go to a care home, so about where a person should live. It even has decisions about who should visit a person. What should they wear? What should they eat? It's quite can be quite prescriptive if you want it to be.
Yeah.
And it also has a part on the actual power of attorney about potentially making decisions about life-sustaining treatment for an individual.
So the assisted dying bill is obviously making its way through Parliament at the moment, and it's received a lot of press. But my understanding is that that will apply only to people with capacity, and that attorneys aren't going to be able to make any decisions under the assisted dying bill. What sort of powers do people have then in relation to life-sustaining treatments currently?
I mean, you're absolutely right. Yeah, the assisted dying bill. The key thing to note with a health power of attorney is that an attorney is only able to make decisions when the donor is assessed as lacking capacity to make their own decisions. So that is different to what we will talk about with the financial one later on. But at that point, obviously, The assisted dying bill is very specific that a person must have capacity to make their own decisions with regards to assisted dying. So attorneys aren't able to make any decision with regards to that. What they can do is relating to life-sustaining treatment. In the context of a power of attorney, life-sustaining treatment probably has a much broader meaning than most people think of it as. Most people think of life-sustaining treatment as not wanting to be kept alive on a ventilator, something like that. And of course, that is absolutely a part of it. But actually, life-sustaining treatment within the context of a power of attorney could mean making decisions about somebody having a treatment for cancer or somebody having an operation for like a heart bypass operation, even something as simple as a decision on needing a course of antibiotics, for instance, because somebody's got pneumonia and they're not going to survive without it. So they do have the ability to make those sorts of life-sustaining treatment decisions.
And would you normally have a living will or directive about your wishes for medical treatment in the future as well?
Yeah, so an advance directive, oftentimes living wills and advance directives, they can sometimes be interchangeable and people use them for the same sort of thing. That is the more specific document actually detailing in a certain circumstance, these are the decisions that I want to be made in respect of any type of treatment to sustain my life. Now, it is important to note that if you have set up an advance directive and then you subsequently set up and sign a health power of attorney, the power of attorney and the decisions you make in there will supersede any advance directive. So do be aware of the timing of when you do things. But it is possible for you to be prescriptive about the types of decisions which you would like your attorneys to make. So in the power of attorney, you can leave it very broad and open and just say that you would like your attorneys to have authority to make decisions about life-sustaining treatment. And you're not specific within the power of attorney on the types of decisions or circumstances that may arise for them to make those decisions. In an advance directive, then you can be more specific about if you had particular religious beliefs, for instance, of you wanted certain decisions to be made or not made with regards to treatment based on those beliefs. That is where you would place some specific decisions. You can also put them in the power of attorney as well. And oftentimes these days, certainly I advise people that it is often easier to keep everything all in one document rather than having lots of different documents. So that's worth discussing with an advisor as to the types of restrictions, conditions, preferences, and instructions that you can put on your powers and in your powers to make sure your attorneys do follow your wishes.
Yeah. Okay. So if we move on to property and finance LPAs, then I think you touched briefly on the fact that they're slightly different to the health and welfare attorneys in terms of when you can use them.
That's correct. Yeah. So a property and financial power of attorney there are two options within the power of attorney as to when you can actually start using them. And depending on the option that's chosen at the time they're set up by the donor would depend on when they were available to be used. So the first option, and this is the option that most people choose, is that they can be used as soon as they have been registered. And that means that you could use them at a time when a person does have capacity. And they are used quite often in those circumstances. So we often have people where they're perhaps getting a little bit older, a little bit worried. A lot of things these days are all dealt with digitally, and perhaps older people struggle a little bit to deal with that. So they want assistance from their children, but they certainly have capacity. And the idea behind that is that they are the people still making the decisions, but it may be the attorneys that are carrying out those decisions. Again, it's useful for people who are perhaps more physically disabled and would struggle to get out to different places to be able to assist with finances, property, etc. The power of attorney can be very useful in those circumstances where the attorney can assist them, but they are still able to make their decisions.
Yeah.
The other option with when property and financial affairs power of attorney can be used is you can decide to have it only when you don't have capacity. So that is an option on the power of attorney, not used that much, because the key thing with any power of attorney is that you must choose attorneys that you trust, that you know will act in your best interests. So the idea behind that would mean there should be less restrictions on the power, because your attorneys would only act in an appropriate way because you've appointed the right attorneys
Yes.
for dealing with matters. Yeah.
So what could you do with a property and finance LPA then? So you obviously have powers to manage people's finances, but what would you be able to do in terms of property? Would you, for example, be able to make a decision about somebody moving into a care home and selling their home?
So the property and financial affairs power of attorney, you are not able to make a decision about where the donor should live. That is reserved for a health and welfare power of attorney. So they would be the people deciding on where the individual would live. But the property and financial affairs power of attorney could then, for instance, sell a property to facilitate that. So if health power of attorney has decided that an individual now needs a care home, they need, or perhaps a nursing home, they have high level needs that they cannot remain at home any longer, they would make the decision about that person moving into that home. And again, just to reiterate that the individual would have to lack capacity for the health power of attorney to make that decision. And then once that decision has been made, the person's moved out, the financial power of attorney could then decide to sell the house to facilitate the payment of care fees in the future.
Okay.
Oftentimes they might be the same people. So, if you are appointing your children, you may have them as the health and the property powers of attorney, and that's fine. And that's perfectly standard for it to be the same individuals.
Mm-hmm. And so, I mean, it's obviously you said you need to choose people carefully that you have a great deal of trust in. There's a big burden, really, isn't there, on the person acting as attorney? What are the sort of duties they have, and are there any limitations or restrictions on what they can do?
Yeah, so you're absolutely right that the burden on a power of attorney is very high. It's a very important role to take, and the main decision you can make is choosing your attorneys very carefully, because even with your children, there may be some that simply aren't able to act. They may have many things going on in their own lives, which makes it very difficult for them to be able to take this additional responsibility as well. And there are a lot of duties to make sure that they adhere to. In particular, there is a duty to make sure that they keep records of everything that's done. The main duty, or the main principle, if you like, behind the Capacity Act is to always act in your best interests, that they should keep your money separate from their own, that your money remains your money as well. So it is not a case of them being able to do as they wish with it, that it should be used for your benefit, for your maintenance, care, anything like that.
As a contentious probate solicitor, I often see disputes involving how power of attorneys have been used. So oftentimes it will be other family members who are concerned that the attorney might have gifted monies to themselves or, other members of the family, or they may be dealing with property in a way which is ultimately going to benefit them, depending on what the will says. And of course, that really shouldn't be how an attorney is behaving, should it?
Exactly right. Yeah. So we do come across this from time to time, absolutely. And obviously refer matters over to you about this, that, an attorney does have a responsibility to the donor and a responsibility to ensure that their assets are dealt with properly, looked after. There are very limited powers in respect of gifts that are made for a power of attorney. And one of the key things is actually for a power of attorney to review what a will says, because ultimately the will may have some gifts within it which the attorney needs to be aware of during the donor's lifetime to manage the assets in such a way as to not defeat the wishes within the will. So it is, absolutely important that you choose the right attorneys that you know are going to do that to stave off any issues that may arise in the future.
But you wouldn't be as a donee of a financial property LPA, you wouldn't be able to revise somebody's will, would you?
No, absolutely not. Yeah, no, it's specific that attorneys do not have the power to make changes to an individual's will. The only people who can change a person's will is either the individual themselves, if they've got the required testamentary capacity to do so, or indeed the Court of Protection, in limited circumstances, could set up something called a statutory will. But it is quite limited and very specific reasons why somebody may need one of those.
So we've looked in quite some detail then about what you can do specifically with the health and welfare LPAs and with property and finance LPAs. Do you want to just tell me a little bit about why it's important to do this and why it's important to think about it as soon as possible? You know, what would happen if you didn't have an LPA?
Yeah, absolutely. So, I mean, the key takeaway from this podcast would want to be for people to set up powers of attorney at a time when they are able to. If you leave it too late and you do not have a power of attorney, then your oftentimes next of kin or closest relatives would need to apply to the Court of Protection to get something called a deputyship order to manage your affairs in the future. It really is something to be avoided unless absolutely necessary. The Court of Protection, the application process is very long, it's very expensive, it's very complicated, takes a long time to actually get the order in place, oftentimes between 6 months and a year. So you may then not have access to funds or money or be able to pay the bills during all of that time period. And then even after a deputyship order is set up, it's a lot of administrative burdens on the deputy. And the court really does retain overall control of the individual's assets. And you have to ask the court permission to do certain things. So power of attorney really is a way in most circumstances to avoid that if you set it up as early as possible, it then sits there until such time as it needs to be used. I often use the analogy that powers of attorney, people should think of them like insurance policies, that you have car insurance that you take out every year, and every year you pay a premium for that insurance, and the hope would be that you never actually have to make a claim on it because nothing happens to your car. But in the event that you did have a car accident, or car was broken into or stolen or something like that, that insurance is there for you to claim on to be able to then move forward and purchase a new car, whatever it is you want to do. It's really similar with powers of attorney. You may set up a power of attorney, and the best case scenario is you never see this power of attorney again, that it sits in a cupboard or a drawer or sits with the solicitors who have set it up, and you are fine for the rest of your life and you don't need any assistance in managing your affairs or making decisions about your medical or care decisions. But if you did need those decisions making, of course, these days we are all living longer. The advances in medical treatment are such that we are being kept alive for longer. But the brain is like any other muscle and can deteriorate over time. So the rates of people losing capacity are increasing. And to have that reassurance that if something did happen to you, you have got the necessary documents in place, that it would be a smooth transition to your attorneys at a time which is likely to be fraught, very emotionally fraught for them if they're having to deal with perhaps considering having for you to go into a care home or those really big life decisions. The last thing anybody wants to be worrying about really is, oh, can I have access to the bank account and can I pay the water bill and the gas bill, etc. So with a power of attorney, you have that document ready to go and can activate it as soon as possible to allow your attorneys to continue managing matters.
And presumably, it's something you would advise people to review regularly in the same way they would review their will with any change of circumstances in their life. You can, if you just change your mind about who you want to be your attorney, or you decide that somebody who you had appointed as an attorney is not going to be the person you would want to take that role any longer, whilst you have capacity, you can change that, can't you?
You can, that's right. So, I mean, what I would say is we do advise people it's important to get decisions right from the outset if they can. Obviously, of course, you can't plan for life events, etc. But the way in which powers of attorney work are that once it's set up and registered, it's relatively easy to revoke the appointment of an attorney, so remove an attorney from an existing power of attorney, but you cannot add any attorneys on to a power of attorney that's already been registered. You would actually have to start again, go back to the beginning and do a whole new power of attorney. So because you've got the option to appoint many different people as your attorneys, it's always worth having, at least 2, maybe 3, maybe 4. So if you've got 3 or 4 children, put all of them down, and you can actually appoint them so that not everybody has to act all at the same time.
Mm-hmm.
So the power of attorney is quite flexible, and it gives you options of, if you've got more than one attorney, whether your attorneys act jointly or jointly and severally. There is a third option as well that not many people use, but most people go with jointly and severally. And what that means is that any one of your attorneys can act at any one time, and it doesn't require all of them to do everything. So you could put them all on the document, but for instance, if you've got 3 children, oftentimes there's one that tends to take the lead or may do the day-to-day running of matters, and they'll do that, and they can do that by themselves without the other attorneys, but the other attorneys are there just in case anything happens to that one individual. The others can step in as well. So it is always better to try to get the right people in there from the outset. But yes, you can absolutely change it if you've got capacity. Obviously, it cannot be changed after someone's lost capacity.
So, I mean, there's obviously a lot to think about there, and it seems that it's probably something we should all be thinking about putting in place to have that insurance policy. What for you are the key takeaways that people should be thinking about in terms of putting in place LPAs?
So I think the key takeaways are that you should make sure that you get a power of attorney as early as possible, and that you elect for both powers of attorney. They do deal with very separate areas. So it is best to have both the property and financial affairs and the health and welfare one. It's important that you choose your attorneys very carefully, and that you consider any preferences and instructions that you particularly want to place on powers. If you do have certain beliefs, or ethical beliefs about where you do and don't want money invested, etc., you can consider all of that when setting up a power of attorney. And oftentimes that's where a solicitor's advice can be very useful about ensuring that you have considered all types of eventualities that may arise, and the different types of information you can place in your powers of attorney to actually assist your attorneys in the future when they may be managing your affairs, and that your wishes are carried out.
Thank you, Emma, and thank you for listening. Of course, if you would like more information about LPAs or any of the issues that we've discussed in this episode, please do visit our website at dmhstallard.com. And we hope you'll join us again for another episode of the Private Wealth Podcast.